Hello and welcome. I am joined by my colleague Sarah Kucharski, one of our Park Memorial Aftercare specialists, and Megan Koper, Wills and Estates lawyer with WillWise. My name is Kristi Hammond and I am Public Relations Coordinator for Park Memorial Funeral Home. It's my privilege to welcome you to our second in our series of Wills, Estates, and Final Wishes. I know that we had planned to talk about all things probate today, but I was really taken aback by the things that we learned in our discovery meeting in preparation for today, things about the obligations that we owe to our dependents, especially in scenarios that are so common right now with blended families, second relationships, those kinds of things, as well as the importance of choosing an executor and the outcomes that can happen when you don't choose wisely your executor. And so we decided to tackle these topics first, and we'll be talking probate in our third event coming in the new year, which I'm really excited about as well. Our goal with these events is primarily to educate and give you factual information without judgment that will make decision making easier. Our hope is that we inspire you to take action in a way that is meaningful and intentional for you and your loved ones. Before we get into the meat and potatoes of our discussion, Megan has an important message to share.
Hi everyone. Before we get started today, it's important to share that our discussion is for informational purposes only and not to be considered legal advice. The answers to your questions can vary significantly based on individual circumstances, and new information may lead to different conclusions. Please seek appropriate legal advice before acting or choosing not to act upon the information we provide. Also, some of the specific rules we'll be discussing are based on Alberta law and may vary outside of Alberta.
Thanks, Megan. So here's a real life situation. When Stuart died at 63, he was survived by his spouse of 17 years, Sharon, one son, and 4 daughters from a previous relationship, 2 of whom were in financial need. He appointed his son Anthony and his daughter Charlene as executors. His will left Sharon certain assets, including their home, an SUV, and 20% of the rest of the estate, with the remaining 80% going to his daughters. Sharon applied to the court to vary the distribution of the estate, claiming she was not adequately supported. In Alberta, spouses and long-term partners have rights that can take priority over those of even independent adult children. Megan, can you share what happened with Sharon's court claim?
Certainly. So this was a real case decided by the Alberta Court of Queen's Bench, as it was known at the time. And it highlights a really important principle that we owe both a legal and a moral obligation to our family members, particularly our spouses, to provide adequate support for them when we pass away. And if we don't, the court actually has the power to redistribute our estate to ensure they're properly cared for. So in Sharon's case, the court found that she had a strong claim for the estate to be fully redistributed to her. So she received a significant lump sum, with the remainder to be held in trust and paid to her for the remainder of her life or until the funds were exhausted, whichever happened first. So while we don't know exactly how this ended, it is quite possible that Sharon did receive the entire estate in this case.
And Megan, what sort of things or steps would people take in order to avoid this type of situation?
The main thing is that when a person is preparing their will, it's very important to give real thought to and possibly receive advice about what actually constitutes adequate support to provide to a spouse or partner. And of course, this can be tricky because what might seem adequate at the time the will is made may no longer be so at the time the will is interpreted after the person making it has passed away.
So Megan, could a prenuptial agreement be helpful to limit what a person is required or obligated to essentially put in their will for their spouse or partner?
Prenuptial agreements certainly have their place, and similarly cohabitation agreements. At the same time, there are some limits to what they can do in this situation. They can certainly help clarify spouses' obligations to one another And this alone can decrease the likelihood of a claim down the road. At the same time, it's important to know that the court considers the legal and moral obligations that we're talking about to a spouse to be of the highest order. So they're taken very seriously. And because of this, agreements like cohabitation agreements and prenups cannot be used to contract out of the obligation to provide adequate support.
So they can't just say, I'm leaving you nothing. That's fair. This is an incredibly important topic. I honestly had no idea before we were planning for this discussion that just because something is written in your will doesn't necessarily mean that it will be carried out. For instance, you shared, Megan, that if I was to leave my entire estate to my favorite charity and not look after my spouse or long-term partner or dependent children, legislation would protect them and allow them to claim and receive my estate instead, which is very interesting information that I don't think a lot of us probably readily know.
Yeah, it's surprising to a lot of people. I don't think it's a well-known fact.
So with that in mind, when you prepare a will, what information do you ask from your clients and why?
I always start by asking my clients to share detailed information about their family, their property, and their wishes. And I do this for a wide variety of reasons, but one of the first things I'm looking for is whether there are people in their lives who they are legally obligated to support. And if so, we will start by discussing those obligations and potentially balancing among a variety of obligations. On the other hand, if they do not have any dependents, I'll know that they have a greater flexibility to distribute their estate however they may like.
So Megan, can you tell us who essentially are the individuals that would be legally protected?
Alberta legislation outlines a category that it refers to as family members who we are required to adequately support when we pass away. So the people who would fall under this umbrella are spouses or partners, children who are minors under the age of 18, adult children who are unable to earn a livelihood because of a disability, children between the ages of 18 and 22 who are dependent on us because they are full-time students, and lastly, under this umbrella can be grandchildren or great-grandchildren who are under the age of 18 and who we acted as a parent to at the time we passed away.
This actually makes me think of the order of priority that also exists regarding who has the authority to make funeral arrangements when there is no will or an executor. Throughout my career, I've guided many families and individuals through funeral pre-planning and the process, and where they have chosen what they want for their funeral and their final disposition and what that needs to be. This process also protects their financial investment from inflation, as well as eliminating heavy decisions from their loved ones after they're gone. Sadly, sometimes I've sat across the table in those arrangements several years later, only to find the executor overturns their loved ones' arrangements they've had in place just simply to increase the value of the estate. I think it's an important question that we ask: where does an executor's power begin and end, and why it's so important to choose an executor? Megan, can you give us some insight on that?
Sure. The executor's job is to carry out the terms of the will, if there is one, and follow the law. So they're required to do so acting honestly and in good faith, take all the steps required to administer the estate with care, diligence, and skill, and to do so in a reasonably timely manner. And it's really important to know that even when an executor is acting within their authority, they still have broad discretion as to how these steps are carried out. So some examples of this include deciding when to make distributions to beneficiaries, whether to sell assets or distribute them in kind, the timing and the manner of sales, things like real estate, how to invest estate assets in the meantime. So all of these things can have a real impact on the impact, or shall I say, on the experience of the beneficiaries, how fairly they perceive the process to be, and how, frankly, comfortable it is for them.
That could have huge impact on a family and a relationship for years to come. And what can happen if an executor is not behaving properly? You know, if they're acting beyond the discretion that they're supposed to have.
That's a very good question. If an executor is not doing their job properly, the court has the authority to step in and hold them accountable. So the court can do things like order them to carry out their duties properly, place limits on their authority, and even remove them entirely if they consider that appropriate. In addition, if an executor mismanages funds or makes inappropriate judgments that decrease the value of the estate, things like mishandling assets, making improper payments, they are actually personally responsible for those actions and required to pay back those amounts to the estate out of their own pocket. Actually, in the case of Stuart's estate that we were speaking about earlier, those executors were found to be acting improperly. So they did a variety of things. They paid out estate funds, even though they knew Sharon's claim was pending. They failed to make mortgage payments on the home that Sharon was living in, and they caused the home to go into foreclosure.
Wow.
And that, in addition to just impacting Sharon in her personal life, it demonstrably decreased the value of the estate, and they were found not to be acting neutrally, and they didn't provide appropriate information about the steps they took when they were required to do so. So what happened as a result, they were required to pay back the improper distributions. They were personally liable for the losses to the estate that happened as a result of their decisions. The compensation they were owed was reduced, and they were required to pay their own legal costs instead of them being covered by the estate. So this had a real significant impact.
Wow.
While this court process is available, I can't even imagine it's easy for beneficiaries to actually hold an executor accountable for these types of actions.
That's exactly it. So while the process exists, it's by no means easy for beneficiaries to navigate. Taking an executor to court requires significant time, money, and emotional energy, and not everyone has the resources or the support to take that on. And even for those who do, it is not an easy or stress-free process.
Well, this really drives home why choosing the right executor is so incredibly important. Maybe can you talk about some of the traits that are important for people to want or need in their executor?
One of the most important things to look for in an executor is someone who's trustworthy, and ideally someone whose values are aligned with your own. We also want to appoint someone who's organized and financially literate, because they'll be managing a lot of details, deadlines, and decisions. Family dynamics matter too. So a good executor will be able to act calmly and communicate clearly if tensions arise. They will also be reliable and available, so live nearby and be able to make time within their lives to take the steps required to administer the estate.
Yes, we see often that money becomes tricky with family dynamics, for sure. Now, you mentioned when we were preparing for today that every will that you draft includes a clause stating that an executor who moves to the United States or lives in the United States is disqualified from acting as executor. Can you explain the reason behind that?
For sure. The main concern here is that if an executor is a resident of the United States, the estate could be treated differently for United States tax purposes. They may face extra reporting and compliance requirements, both of which add to the cost and the complexity of dealing with the estate. Also, for practical reasons, it is just harder to administer an estate from another country. Things like signing documents, in-person meetings, particularly at financial institutions, handling the sale of property, all these are more difficult to do cross-border. So for this reason, an executor who lives in Canada, and even better in Alberta, usually makes the process smoother, faster, and less costly.
So something really to consider for parents whose kids maybe are adult children are going to go to school in the States, or there's a possibility that could happen. They would want to really think that through if they were appointing that child or that adult child as their executor.
That's right. And the beauty of drafting this way is if you think maybe they'll come back or things are uncertain, you can appoint them if they're the preferred executor, but at least they won't be able to act and cause these less than ideal results if they are resident in the U.S. at the time you pass away.
Wow. Well, thank you both. This has been, again, an eye-opening and valuable discussion. We've covered a lot of ground, from how Alberta law can override what's written in a will, which I had no idea about before we started preparing for this event, and the importance of updating your documents and having clear conversations with your loved ones. Megan, you've helped us see that an executor's role carries both authority and accountability. That personal accountability, that if they act outside of their responsibilities, that they can be held personally liable and accountable, and that choosing that right person who is trustworthy, who is organized, and who can make fair decisions can make an enormous difference in how an estate is settled and how those family relationships that are so important are preserved.
Definitely.
And Sarah, your perspective really brought this to life, especially when we think about how funeral pre-planning ties in with the legal side of things, and reminds us that planning ahead isn't just about, finances and paperwork. It's about protecting the people and wishes that matter most to us and making sure that those are looked after.
Absolutely.
So with this foundation of information, we're going to shift into our question and answer. We've received some what ifs and some questions from people regarding wills and executors, and I'm excited to get into those questions. So the first question is from Helen. What happens if my will is lost or destroyed? So destroyed, maybe I destroyed my own will, or maybe there was a flood or a fire. Can you answer that for us, Megan?
Sure. So the answer to Helen's question really depends on the circumstances and the intentions of the person who made the will. So if they destroyed the will with the intention of revoking it, that does revoke the will. However, if the destruction is accidental or unauthorized, so for example, a flood, the terms of a will are still attempted to be followed as long as the contents of the will can be proven. So this can be done by providing a copy, a draft, or even witness testimony or some combination. On the other hand, if a will is lost and not later found, it is presumed to be destroyed and therefore revoked unless there is evidence to the contrary. So as you can appreciate, either of these situations can create a lot of uncertainty. It's difficult to prove what happened and what was intended. So the best course of action, if the person who made the will is around and mentally competent, to make a replacement will.
We have a question from Deborah actually wanting to know, do wills ever stale date?
Wills do not stale date in the same way that checks do. I've actually probated multiple wills that were over 50 years old. Wills remain valid until they are revoked, like we talked about. The issue with very old wills can be that they may no longer be well suited to the person's circumstances or to their wishes. Even so, they can remain legally valid.
Are there things that you tend to build into your wills with families or client families in case they don't get updated?
Yes, definitely. This is why we usually draft wills in the broadest terms possible. I'll generally avoid listing specific real estate or bank accounts unless there's a particular reason to do so. This gives the document greater flexibility and greater longevity. So if you move financial institutions or buy and sell a home, you wouldn't necessarily have to be updating your will. I'll also include clauses to anticipate changing circumstances, like you alluded to, in case the will isn't updated. One example that I commonly use is if the will maker has young children, we'll say that if a child dies before receiving their share of the estate, it would instead go to their children, so the will maker's grandchildren, even though those grandchildren may not be born for some time.
So another question that came in from multiple people: what are the implications of appointing joint executors? That was a big hot topic question.
This is a common question I receive as well, and many people find the answer to this one surprising. When executors act jointly, they must make decisions unanimously. They actually have to agree on everything. So while this can create checks and balances, which is why I think it can be very appealing, it can also lead to delays due to disagreements or even a complete standstill in the administration of the estate. It can also mean more work for two people to coordinate on things that one person could have done. Things like in-person meetings or signing documents, because both people need to be present. It can't just be, one or the other attending. Another important thing to know is that executors acting jointly are jointly and severally liable for how the estate is handled. And what this means is that each of them can be held responsible for the management of the entire estate. So for this reason, it's very important for executors to know and trust one another before agreeing to act as executors together.
Wow.
So what sort of feedback would you give to parents who ultimately want to choose all of their kids? They have 3 children. In the eyes of our parents, they want to see our kids as equals, and they want to assign that role to all 3 of them jointly.
I completely understand the sentiment and the thought process, and I do get asked about this a lot. And the request I make of my clients is that they take this back to their children and have the discussion with them. And most frequently, the feedback I receive after the discussion is that the children do not place the same importance on the executor role, and they see that it is not easy, not a fun job to do. So this enables the family to have a discussion together of which of those children, and maybe in what order, may be most appropriate to act as executor. This may be due to location, expertise, family dynamics, or some combination of these things.
So they may even talk themselves into the role and excuse themselves from the role ultimately.
That's right.
So on that note, can an executor choose not to act? So if you were to name me as your executor, can I say no thank you?
You certainly can, particularly if you have not accepted the role and have not yet acted in the role.
Okay.
Then you can fill out a form that formally renounces your role as executor. On the other hand, if you have acted in the role or held yourself out as the executor, then you would need approval of the court to step down, and that would generally only be granted in more exceptional circumstances, such as, incapacity or maybe a conflict of interest. So it's a very serious role to consider the implications before you start acting and before you accept the role.
We had a question from James. He's asking, does an executor get compensated for their role?
Well, James, they certainly can be compensated, and this ultimately depends on what the will says and whether the executor actually decides to claim compensation. So if the will does not set an amount, the law allows for fair and reasonable compensation. And this is based on things like the size and complexity of the estate, as well as the time and the effort involved to administer it. Another option is to set the amount of compensation right in the will, or alternatively to state that the executor is not entitled to compensation at all and may only be reimbursed for out-of-pocket expenses. So we'll often see this as the executor being entitled to a fixed dollar amount, or maybe a percentage, or even a formula that incorporates both. And this can help avoid what sometimes can be an uncomfortable issue for the executor and the beneficiaries to sort out later.
So Megan, can there be challenges with setting a fixed dollar amount instead of a percentage?
There definitely can. Once you set a dollar amount for executor compensation, this is what they are entitled to receive, regardless of the circumstances, the size, the complexity of the estate. And we never know what the size of our estates will be when we pass away. So more generous compensation could be problematic if we use a significant amount of our resources, for example, for our care while we're alive. The amount set could be disproportionately large in that case. On the other hand, an amount of executor compensation that's more modest could end up not being enough and may even encourage an executor to renounce their role and not act when the executor is dealing with a very challenging or a complex estate.
So would you say that you're seeing a trend towards setting a percentage instead of a dollar amount?
I definitely am.
Thank you.
In a situation where the surviving spouse is the acting executor, am I correct in thinking that they wouldn't necessarily be compensated for their role?
That's right. While they may be entitled to compensation, they generally wouldn't claim compensation because they are the sole beneficiary of the estate anyway. So it doesn't positively impact the distribution of the estate.
And in the situation where there is compensation paid to an executor, are there tax implications?
That's right. Amounts that executors receive as compensation are supposed to be included in their taxable income. Even gifts that they receive in lieu of instead of compensation are supposed to be included in income in the same way.
Well, thank you, Megan and Sarah, for another informative and thoughtful discussion. Thank you, everyone who joined us today. I know these conversations can feel heavy at times, but they're also very empowering, because the more that we learn, the more confidently we can make decisions that protect the people that we love. I hope this session has helped you think about your own planning in a new way, whether that's updating your will, reviewing your executor choices, or simply starting the conversation with your family. I also want to remind you that Park Memorial's commitment to supporting families goes far beyond this event. Each month we offer Art for the Grieving Heart and Men's Grief Support programs, which are both open to the community, as well as other grief support gatherings throughout the year. These events are created to ensure that no one has to walk through grief alone. We will be back in the new year with our third session in this series, and we'll be diving into the topic of probate, what it really means, how long it takes, some changes to how things are done in Alberta, and how to make the process smoother for your loved ones. Until then, please don't hesitate to reach out to our team at Park Memorial or to Megan and her team at WillWise with any further questions. Thank you again, and we hope you will join us in January.